And we are live. Good afternoon, everyone. Welcome to another episode of our amazing podcast. This is Foreign Investment Fridays. My name is Hector Aguilar with Aguilar Realty Group. And today we have a special episode for you. Today, we're going to be diving into a critical topic that affects nearly every homeowner: why you need a living trust, the ugly truth. I'm joined today by a top estate planning attorney, Liz APODACA of My Attorney LA, who will break down the real risks of not having a living trust and why it's more than just a piece of paper. If you think a will is enough, or you've been putting off estate planning altogether, this conversation today is going to open your eyes. Stick around. You don't want to miss these life-changing insights. Good afternoon, Liz. Thank you so much for making the time to be with us today. I'm excited once again to host you as our guest for our podcast as we touch an amazing topic, a very sensitive topic, and that is living trust. The title for today is Why You Need a Living Trust, the Ugly Truth, and thanks for making some time for us, Liz.
Oh, my pleasure. Thank you, Hector, for hosting me today. Today, we're going to talk a little bit about some ways that probates have gone wrong. Mm-hmm. So just as a quickie intro, I do set up living trust. That's the best way to handle or to own property for most people. And that's what avoids probate. That's the main benefit of having a living trust is you don't have the expense, you don't have the time, you don't have the energy and emotion of having to go to the probate court. And, by cost, I'm talking, $20,000 and up. It's just very expensive and also creditors. So it's really like an unforeseeable black hole that could, happen. And so I'm going to focus on some things that are other than that. Some in my experience of some of the problems that have happened when people don't plan or when they have the wrong kind of plan.
Right.
Okay.
Right. It's interesting. When I reached out for you for this podcast, it seems to me that most people learn from experience, right? From other people's experience, or maybe even some stories that they've heard. And they have this thing about maybe, it'll never happen to me, right? It couldn't happen to me. It's not going to happen to me. Well, today, the topic of our conversation is going to be a little bit more sensitive because I want you to share with us some of the experiences you've had with people that didn't plan or planned badly, right?
Right.
And we're titling this Probate Gone Wrong, right? Because I think most people learn from pain and not necessarily from planning. So go ahead and share with us what your plan is for today.
Okay. And also I want to apologize. My voice is a little raspy today. I may be coughing a little bit, so I apologize for that. It's just, a consequence of the changing weather and yes. I don't know.
I think a lot of people are going through it. So if anyone has any questions or issues, look, we're going to have a question and answer session, or you can actually book a consultation with Liz on our behalf. And again, so, you're okay. You'll be well.
Okay. So let's get started then.
Let me go ahead and add the slides. Here we go.
Okay. So yes, we're going to talk about the unintended consequences of bad planning or no planning. That's, so as I had already mentioned, you want to avoid probate. That would be the number one goal for every homeowner, is to avoid probate. With estate planning, and I capitalize there, proper estate planning, probate is totally avoidable. It's avoidable for every single homeowner. And by proper estate planning, I mean, get the right kind of legal guidance that's, personal to you. Don't settle for just, getting some forms in the mail or doing a do-it-yourself, because those are the kinds of things that cause the kinds of problems that I'm going to talk about in a few minutes or throughout this whole day.
I really appreciate you mentioning that, because a lot of people tend to want to save money, right? They're like, well, I really don't want to spend or invest in this particular document. There's several do-it-yourselves. There's other like self-help and even assist you type of planning companies out there, estate planning companies, and they just it may not be the best solution for you. So if anything at all, if you're going to learn something today, this is one area of your life as a homeowner that it's absolutely important that you invest the proper amount of money and doing a proper estate. You'll be glad you did. Believe me,
yes.
You will be glad you did.
Yes, and we try to keep our fees reasonable, and I know that there are some places where you can pay in excess of $4,000 or $5,000, but
Mhm.
we don't do that. We keep it very reasonable, but at the same time add value by, making sure that everything is correct, making sure that you understand everything before you sign, and then we follow through with the funding, which is the most important part of estate planning, is getting
Correct.
that property titled into the trust. So
Right.
we handle all of those steps. It's very
Fantastic.
painless. Okay.
Wonderful. Let's talk
Yes, but
about
now let's
scenario
talk
number
about
one.
our scenarios.
Yes.
Okay, so the first one is tenants in common. So most married couples own property in joint tenancy, but a lot of times people will just assume it's in joint tenancy, and then what that means is that when one homeowner passes away, the
Mhm.
other person who is the joint tenant is automatically now the owner. But there's certain technical requirements that have to happen for a property to be deeded into joint tenancy. First of
Okay.
all, the deed itself has to be very explicit. It has to say the words joint
Okay.
tenancy with right of survivorship.
Okay.
It has to be like, at the same time, if you get property, like two people get property from two different sources
Mhm.
or at two different times, that's not a joint tenancy. It has to have the same amount of ownership. In other words, both, or however many owners, however many joint tenants, they all have to own the same amount, which is 100% of the property.
Wow.
Because when the last one is standing, they own 100% of the property. But for those deeds that are defective, maybe they were prepared by, I don't know. There's all different kinds of ways that people, a lot of people just, I've seen handwritten deeds where people just do it themselves.
Wow.
I had a probate once where the deed itself was, in print. It was like a printed form, and the top of the form said joint tenancy deed,
Oh,
but the
wow.
language wasn't included that said joint tenancy. And so then we had a tenant in common issue that delayed the probate by at least a year, because then we had to find all the heirs, and we had to file a separate petition to get the property back into the probate
Understood.
of the deceased persons. And in that case, it had been the grandma. So there's a lot of different kinds of scenarios. I deal with these a lot where,
And I would assume that
I
you
just,
probably deal with them a lot because in most cases, when someone buys a property, this is the tenant, the way they take title is the most common way that I see,
yeah.
right? When I deal with my buyers and my clients, I always give them options, and I give them a table, and I explain, what each of them means. And I even ask them, if you'd like, I can refer you to an attorney who's going to give you better, because I'm not an attorney. I didn't practice law and I don't know the law, but I have enough common knowledge to know that there's options in how to take tenants or title, pardon me, and how that can affect their ownership. So I always offer to get them a consultation with an attorney, because joint tenancy, as you're mentioning here today, may not be the best way to hold title.
Well, it really kind of depends on the situation. Maybe it is the situation where maybe it's a brother and sister and they each want to own half because it was their parents' property that they inherited. And so they
Right.
each want half.
Right.
But so that wouldn't be a joint tenancy because, you don't want the other one to take 100%. If one passes, that 50% should then go to that person's children. So there's all different scenarios and different personalized circumstances that would kind of indicate how you want to hold title. But most people, they do assume that it's joint tenancy, and they assume that when one of them passes, the other one owns it. I just started a probate a couple of weeks ago where the only reason we started the probate is because of a Wells Fargo bank account. But when I went and looked at that property deed, I found 3 owners on title, and one of them, and none of it doesn't say joint tenancy. So I think that, since we already have a probate open, we're just going to make sure that that property gets titled the
Wonderful.
right way. Right.
Fantastic.
So that's
Well,
what I wanted to say about that. You
here's
just
scenario
don't
number
know.
one. Right. You just don't know. Tenants in common,
Yes.
scenario number one. Shall we
Yeah.
move on?
Yes.
All right. Let's look at scenario number 2.
Okay. So you can see the tree there, and sometimes there's a lot of relatives that are unknown. This has come up in a lot of my cases, too many heirs.
Wow.
There's 2 different ways it can cause problems. The first way is that we don't know who they are or where they are, and we have to find them. So sometimes, not all the time, but sometimes I've had to go hire a company to do the genealogy research, right? To find the people, because, you know, it's sometimes the person who's now processing the probate doesn't even know the real full legal names of all the related persons. Because the scenario is, say someone has 5 children. All of those children, like if it goes through probate, there's no will, right? So we don't have any like indication that it's other than the legal intestate distribution. So they're each entitled to their 1/5.
Okay.
One of my cases, I'm doing a probate of a woman who had died in the 80s, right? She died a long time ago, and it never went through probate because the family was living in the property, they were using it, it was their family home. And that's all fine. But now when it comes to doing the probate, some of those 5 children now are deceased. And so then we've got to find the children of that, you know,
that heir
child. And in the case of the lady that died in 1988, by now we're in 2024, all of the children, the first level heirs, they're now deceased. So now we're going to grandchildren, in some cases great grandchildren, and we have to find them. They all are entitled to notice, and generally they're entitled to a portion of the inheritance.
Sure.
It could be just like 7.5%, but it is what it is. You got to divide it up equally, and the children of deceased relatives do have rights, so they have to be found.
They still have a right to their percentage, whatever small percentage there is. And that's one of the challenges when you have too many heirs and you don't have an estate plan.
Yes. So that is a definite issue. And, it's not common for people to realize, because it's the law, and people don't realize that the children of deceased children, the deceased heirs, do have those rights.
Sure.
And, they could be in another state. They could be, their names could have changed because of marriage.
Sure.
I mean, it's just, that slows things down, and it can cause a little bit of problem, because now once they're notified, some of these, long forgotten heirs, now they may have a little bit of a dispute, or they may decide to hire a lawyer of their own just to make sure that their rights are enforced. So, it just can cause problems. Now,
I had a client recently, just to kind of add some additional experience to this scenario is, I had a client recently where her sons were sought out by the court because the father had passed away, and the grandmother had passed away, who owned a property, and so they had reached out to them, letting them know that now they were entitled to that particular inheritance that would have belonged to the dad who passed away, right? And so I experienced this exact scenario with my clients.
Yes,
it happens.
That is exactly how it works. Is it goes down through the generations. Right. So they have to be found, and they have to be notified, and they have to have, their right to participate in the process. Right. There's also a second problem with this kind of scenario.
Okay.
And this happens even when there's a trust. If you have so many children and they don't get along, then a lot of times that causes problems. So, I've had situations where there was a trust and the children didn't really, get, they don't trust each other. And so they want to get involved.
Or even worse, they don't even talk to each other. I've got a couple family members that don't even talk to each other.
Yeah. So that can be the problem too, when there's so many people. They have to be found, but then they also have to cooperate.
Correct.
Whether it's probate or a trust, they have to kind of like cooperate and trust in the system. And especially through probate, sometimes it's even better to just have property go through probate. I mean, despite all of the potential creditor claims and, other things that happen in probate, the additional cost. But, the judge will make sure that it's done correctly, that everybody's getting their proper share. So there's no way for
a solution for them to go through probate just to avoid the headache.
Sometimes. Yes, sometimes. Because then if they're in court in a probate, their fees are subject to the statutory fee limit, and there's other like more efficient ways of handling things than if they're like fighting over a property that's in a trust. Okay,
interesting.
So that's that one.
All right, let's go to scenario number 3. Scenario number 3.
Yeah, so this is kind of related to the too many heirs kind of problem
Okay.
because, if you've got children of children of children, and then you find them, but then come to find out maybe they're incarcerated, or
Mm,
maybe they're special needs, and more commonly maybe they're not 18 yet.
I
So
see.
if they're not able to pursue their own rights, and especially the special needs incapacitated heirs, then they might need to have a conservator appointed. And for minor children, absolutely, they'll need to have a guardian appointed. I've been able to get some judges to like allow money to go into a blocked account, which just stays blocked until the child turns 18.
Okay.
But not always. Not all judges are amenable to that. They just want to have that guardian appointed,
Sure.
and also order a blocked account. But there's that extra layer of like, now guardian is able to like manage that money and use it for the child if the child needs, maybe tuition expenses or medical expenses or whatever. They can be used for the benefit of the child before they're age 18. But the court will require someone to be legally appointed to do that. And then, of course, there's extra cost and time.
Sure. Sure. That makes
Yeah.
sense. So let's go on to scenario number 4. This is the big one,
Okay.
right? The
This
big
is
one,
another big one. So I kind of had talked about family disputes before,
right?
but the verbal instructions, that's a biggie. So,
Mm,
mom said that I was entitled to this house, or dad said that I can have this particular asset, or
right.
dad wanted me to have all of his, his antique cars, right?
Sure.
So, when there's instructions, but they're not in writing,
Mhm.
then the family just can kind of go berserk. Sometimes, they'll cooperate, but if, it all boils down to trust, and sometimes it just doesn't exist. So
Yeah.
that's a
I'm
sad side of it.
right now. I'm working with a set of clients that I've been assisting for 2 years, kind of guiding them and preparing the property. There was 3 heirs to the property when they first received the property in the trust. The parents had passed away, and it took them a while. So now one of the siblings has now passed on in these last 2 years. So now there's 2 of them. Luckily, they do get along, but I do foresee that there might be some challenges of the distribution of assets once the sale closes. It isn't a trust, so that's a benefit, but the trust may need to go through probate just simply because I don't know if there's instructions in terms of the children of that third sibling that passed away, right? In terms of, being additional heirs and family disputes. So I'm hoping
Yeah.
that they don't have any disputes and that they're able to honor and give the portion that pertains to that sibling and equitable portions to her children or grandchildren, depending on who they have. So I can totally see that family disputes can also be an issue and ultimately prolong a probate process, right? In terms of
Yes,
time
absolutely.
and cost.
Yes.
I can see how
By
that can be also
years.
cost
We're
prohibitive. Yeah, but
talking
years
years.
for
And
sure.
nobody gets their money until that probate ends and the judge orders who's getting what. But that all goes back to, like in your scenario too, it just depends on how the trust is written, and if there's any like vagueness in how the trust is with regard to that third sibling's, children or whatever it is, that, there could be some disputes over what the language of the trust is. So
Sure.
that's why it's super important to just, make sure that it's in writing, like in the clearest way possible. And,
And
usually that means
I think that's where you as as an estate attorney, estate planning
yes,
attorney, where your experience comes in and you can walk someone through the process
yes,
of making sure they write it out clearly as possible
yes,
because we're just laymen. We just want to make sure that our heirs get what pertains to them, right? We don't know all those little details. And that's something
yes,
as a homeowner, you may not know either. And so again, that's why it's so important to, at the very least, have a consultation with an estate planning attorney, such as Liz, and make sure that everything gets written out properly and you protect yourself as much as possible, right?
yes, absolutely. And we don't, sorry, we don't decide, for you how that property should be distributed,
Right.
but, we'll like listen to the goals of the family and make sure we understand, and that, it's clearly put in writing. And if there's suggestions we can make, like, this would make it clearer, or this might accomplish your goals, then
Mhm.
that's what we'll put in the document. But if it's just a boilerplate or if it's very vague, then that can cause problems later on.
I can see how that can cause problems. Well, let's move on to our fifth and final scenario. And this one was new to me when you sent it to me this week, and I really want to kind of dive into this one because this one's something that I've never experienced, but I could see how it might have, obviously be an issue, and that's property being held entitled by a non-owner. Tell me a little bit about that.
Okay, this is a biggie. This is the biggest problem of all. So I'm going to tell you a story about one of my current cases. The lady she owned a home out here in, I don't know, San Bernardino County. Okay. And what happened is she believed she was going to be deported. So she transferred ownership to her sister. She just signed it over, quitclaim deed to her sister who lived in, I don't know, LA County somewhere. So that's fine. I don't know if she went to Mexico or not, but she came back. But ultimately, then the sister died unexpectedly. Okay. She wasn't that old, maybe in her 60s, but she died unexpectedly. So that's the homeowner. So it's her property, and it goes through probate. Absolutely. She didn't need a probate for anything else. That's the only thing that she owned, and it was her sister's house. So, okay, that's fine. The homeowner now that died, she had 4 children. Those 4 children were adults, and they all agreed that it was their aunt that rightfully owned their property.
I see.
So they all signed over an assignment to give it to her. And so that was fine, except for that then one of those 4 children suddenly died. I mean, he was young. He was in his 30s. So, of course, he had minor children. We talked about this already, right?
Right.
Minor children. So minor children, they can't really sign over the rights to their aunt or their great aunt, I guess,
right,
because they don't have the capacity to make that decision.
Correct.
So then the mom, we goaded her and pushed her, and she hired a paralegal to get a guardianship, and it took years. I swear it took years for her to finally be appointed as a guardian. So she's a guardian, and now as guardian, she can assign the children's rights to the aunt. Except for that, I just found out fairly recently that the guardianship order doesn't have that right. She didn't ask for it when she went to do her guardianship, and she actually hired an attorney to help her with the guardianship, and knowing that this was going to be the scenario. Right. So now we have 2 children that are each entitled to 1/12 of the property each.
I see.
And so my client, the aunt, right, she wants to receive this property because she lives in it now.
Sure.
She's been paying the property taxes. She's been maintaining it, et cetera, et cetera. But the problem is she can't really prove that either, because even though she bought the property, when she gave it to her sister, she can't prove that she paid for the property taxes or anything because she just gave her sister cash.
Sure.
Right?
Makes
so
sense.
That's untrackable, and there's no way to prove that it really was her property.
Correct.
And so now the children in the probate court, they have a guardian ad litem, which is an attorney appointed by the judge to represent the children's interests. And she doesn't want those children to sign away their rights. So we are battling this out. I don't know what the end result is going to be, but the problem is that, the non-owner is holding title, right? And if the sister, even if she was deported or whatever, she could have still owned title, even if she was in Mexico, or she should have done something, I don't know, maybe put it into trust. It just given her sister power of attorney. There are other ways that it could have been done. Okay. Absolutely. The more common thing, though, I mean, that's a worst case scenario, right? But it happens. And, if people are worried about being deported, and I get that, I know that that's a real concern.
Sure.
Yeah, but
and it's probably it was a move because she wanted to preserve her asset, something that she owned that was hers, and she felt obviously trusted her sister, right?
Yes.
And she transferred over, unbeknownst to her that her sister was going to pass suddenly.
Yes.
Right?
Yes, and she trusted her niece and nephews, and not knowing that one of them would also pass.
Right.
So
these are some of the scenarios that people don't really think about.
Right.
When they're making these moves, but they happen, right? They happen.
Right. They happen.
Another
And
scenario that I could probably think of in this particular scenario is when parents transfer the property to their son or daughter because, you know, they say they don't qualify for Medi-Cal, or they're afraid that Medi-Cal is going to go after their assets when they
yeah,
pass away, or for whatever reason,
yeah,
they transfer them to the children, and that opens up a whole different can of worms.
yes.
That can
That
also
is the
fall into
bigger
this
problem.
scenario, right?
Yes, that's totally more common. And I see that all the time. And people get advice from their neighbor or their, their friends, their family maybe, oh, just add your child to title or give it to your son or give it to whoever. Okay, so I see this a lot. And
Mm-hmm.
what happens is now, if you're not the owner of the property that you live in and that you've been paying for 30, 40, 50 years, you have no rights to that property.
Correct.
First of all, there's an issue with property taxes. They could
Right.
go up on
They
that
can go up.
transfer, and
Yep.
that's an increase that's paid year after year after year. So that could
Right.
be tens, hundreds of thousands of dollars,
Correct.
really. I mean, literally. And then there are the horror stories where people say, "Oh, this won't happen to me," but it happens to people. Is that their children kick them out? They put them in that nursing home, or
Yep.
they. I've heard like the horror stories of the parents having to move into the neighbor's garage because their home
Yes.
is no longer their own.
Because the child took their property.
Yes,
I have a
yes,
scenario right now where the child co-signed with the parents, right? They transferred the property to him because for whatever reason. You
yeah,
know what he did? He actually refinanced the property, pulled cash out of the property, right? And said, "Hey, this is my home now," and
yep,
essentially kicked out his parents.
yep.
They had to relocate to Utah because they didn't have the ability to buy another property here locally. So it does happen.
It totally happens.
It
And
totally happens.
another scenario is the in-law, okay? The
Oh
son-in-law or
yes.
daughter-in-law. So they could push, their spouse, which is the son or daughter who received this property, totally free.
Mm-hmm.
Um, and without like any rightful ownership, right? But the spouse can push and push, or the spouse can file for divorce and say, well, that property is half of mine, and that happens.
It
That
happens
happens.
a lot.
The divorcing spouse would be awarded half of that property.
So
So
guess what, Liz? I have another client that just happened to 2 years ago. The property is the parents. Okay. They transfer it to the son. I think this happened 2.5, 3 years ago. They transfer it to the son, and the son gets married. Okay. And all of a sudden, they start having problems. And the wife, who had nothing to do with the property, the parents paid the property all their life. It was their property. The son, I don't think the son even made a payment towards the property or maintained it. They get a divorce. And guess what?
yep,
She now has rights to the property because she's
yes,
legally married to the son. And that
that's
happened. The
that's
son had
exactly
to
what I'm talking
refinance the
about.
property,
Yes,
get some
yes.
equity, and buy her out.
Yes. Yes.
Again,
So, I mean, more likely if they really needed the loan, I would suggest maybe look into doing a reverse instead of a
mhm,
refinance. I know the
mhm,
rates were really low for a little while.
yep,
There are some very, ethical reverse mortgages that are
there
out
are.
there that can be a little bit, a better solution as opposed to adding a son or daughter to title.
Right.
Or if they're added just for the purpose of the loan, then immediately after that loan is recorded, then just take them off.
Yeah,
The problem
transfer
is,
that or take them off.
yeah, the problem though is you're going to have a property tax issue
Right.
unless the child
It,
lives
it
in
causes
that
what's called
house.
a property tax incident, right? You have to kind
Yeah,
of do a
yeah,
re-up of your taxes,
yes,
and so you could
yes,
avoid that by also having an estate plan. And you're
yeah,
right, there are reverse mortgage products
yeah,
that are a lot more different than when they first came out many years
yeah,
ago, right? A lot of consumers are more protected. There's
yeah,
there's more incentives for them. Number one is they're protected, and they're not going to be taken
yeah.
advantage of because they
They're
are.
they're not as predatory as they were at
Correct.
the
And
beginning.
many reverse mortgage products, or the most common one now, is actually government insured by the Department of Housing and Urban Development. So their number one goal is to protect the consumer.
Yeah. So I don't, sell those. I don't really, I just say that you got to look at what is the best solution for the
Mhm.
scenario that you have. What is it that you're trying to, do with the refinance? Is it just because the interest rates are lower? Well, I don't know if that's really a reason to
Right.
do that. But, in any case, people do say this won't happen to me. My child is not going to be that like that, but it totally does happen. And then, another bad case scenario, they transfer it to their child, but then their child dies, and now it's the grandchild that has the right to it, right?
Correct.
Grandchild's going to kick grandma out,
Yeah.
right?
And the
It
thing
just
is that
happens.
people don't think about those consequences. They trust too often, and they feel, especially in the Latino community, or in many family communities, they think, oh, my son or daughter isn't going to do that to me. But here's something that most people don't realize is that when it comes to money, all of a sudden greed comes out and their mindset changes. Their
Yeah,
mindset changes. Believe
it's
me, I've
human
seen
nature.
it. You've seen
Yeah,
it. And it's one of the reasons why I absolutely tell my clients, look, after you buy your property, the first thing you should do is consider putting your property in a trust. Talk to an estate planning attorney. I have an amazing attorney that I can refer you to. They'll give you a free consultation. They'll even actually knock off a couple $100 off your estate plan just because I referred you. So please, 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 it's absolutely important. At the very least, have a consultation so you can make an informed decision.
yeah. And
I
I
really,
want to make one more point on the Medi-Cal issue, right?
yes.
So, not a lot of people realize that the law changed in 2017, and the law is now, the current law says that if you have had Medi-Cal pay for your assisted living, um, Medi-Cal will get they'll put a lien on the house, so they'll put a creditor's claim through the probate, and they'll seek to be reimbursed for that. But if the house is in a trust, the Department of Healthcare Services has no option. They cannot get a reimbursement. The trust will totally protect the property from any kind of Medi-Cal lien. So whether or not you qualify for that, that's a different issue. But
Sure.
if you do need that assisted living and California pays for it, then take it. But anyone who's doing that should have their property in a trust because the property will be protected for the family for the years to come.
And at
Okay.
the very least, like you said, maybe not everyone might qualify, but look, if that's your major concern is protecting your real estate asset from a claim by Medi-Cal, that should be your number one reason, if any at all, to at least have a conversation and consult with Liz to see if you qualify. You owe that yourself that because look, all these scenarios happen, and that's the reason why I brought this. Liz and I are bringing this to you as a homeowner is because we want to inform you and help avoid these scenarios, the situation, to protect your assets and to protect ultimately your dynasty and which the inheritance you want to leave to your heirs. Simple. That's it.
Yep. That's it.
So with that
So
in mind, I just wanted to thank you once again. Certainly, these scenarios are important. They've happened. We've seen them. You see them more often than I do.
yeah,
I've been in the business 32 years, and I have seen these scenarios as well, like I shared today. At the very least, I implore our clients and our viewers, schedule your consultation. Send me a DM directly to my cell number. You'll see it here at the bottom. You can reach me at my cell number. Just put in the coupon code SAVE200. I'll make sure that Liz honors that for us, and we'll schedule an appointment with you. In fact, I'm even gonna say that Liz and I are willing to put together an estate planning event, either at my office or her office, to bring in maybe 10, 15 people to discuss it. And maybe you can even have some personal questions so that you can expand that conversation. Because look, there's nothing more important than your real estate asset. You've worked all your life to buy it, to pay it off. It's your largest financial asset that you're going to own. And you need the right legal advice to protect it, not only from taxes or Medi-Cal, but also to protect that legacy and that dynasty you want to leave to your heirs. So with that in mind, Liz, man, I'm so grateful for you. You really don't know how much you reinforce the experiences that I tell my clients. Hey, this is the reason why it's important to have an estate plan.
well, I think it's so important for people to have the right information. So thank you so much for allowing me to share it
On the
with you.
contrary, I'm
Yes.
super, super grateful that you do this for me and our clients. Again, you guys send me a DM. You can email me. You can text me. Just put estate plan and use your coupon code SAVE200. If you want Liz's contact information, I'd be more than happy to provide it to you as well. And at the very least, schedule a consultation. And once you have the information, like we say in sports, right? The ball is now in your court, but at least you're better informed, right?
That's right. Absolutely.
Thank you again for joining us this afternoon for an amazing episode, something that's going to that could protect your assets, something that's going to protect you and your dynasty. Once again, I'm Hector Aguilar. Thanks for spending some time with us. And this has been another episode of Foreign Investment Fridays. Thanks again. We'll see you in the next one. Take care, everyone. Have a good afternoon.